I think the Victoria Law Foundation included me too, so here I am talking about economic theory on plain English Day. But I think the starting point for looking at a proper safety net for legal assistance in Australia is recognising that the market isn't addressing the need for the community's need for legal services, and that these legal services are vital to upholding the public good of an accessible and fair justice system. The fact that legal services aren't affordable to many Australians, particularly where litigation is involved, is widely recognised. High cost of private lawyers, and led various commentators such as former Attorney General Robert McClellan to say, if you're from Middle Australia and you want to embark on a substantial piece of litigation, you really have to put your house on the line. Costs like this are also a significant factor behind high rates of self-representation, around 30% in the family court, higher in other jurisdictions. Mechanisms like window fee agreements, litigation funding and class actions alleviate the unaffordability, but only for a few whose legal issues fit the right criteria, predominantly personal injury matters. The reality is for many Australians, the private market for legal services is beyond their reach. The Australian Institute earlier this year conservatively estimated about 500,000 Australians miss out on the legal help they need, mainly for financial reasons. Given the moral imperative of ensuring that justice is accessible for all, governments need to ensure that where legal services are required to obtain a just outcome, those legal services are available to people who otherwise can't access them due to cost or other factors. In other words, just like we've got a safety net for education and health in Australia, we need a proper legal safety net. Imagine if you started building this safety net, what would it look like? How would you build it from scratch? In terms of the principles that should underpin the safety net, I think we've broadly got it right with the current National Partnership Agreement. For those who aren't familiar with this agreement, it's basically the overarching agreement that guides, it's a COAG agreement guiding how states and territories and legal aid commissions should deliver legal assistance services. NPA for short focuses on early intervention, prevention and the 5 access to justice principles. These principles are accessibility, which should aim to reduce the complexity of the system and allow people to understand and enforce their rights. Sorry if this is basic, but I think it's worth repeating these principles. Appropriateness, the system should encourage people to resolve disputes at the most appropriate level and should direct attention to the underlying causes of legal problems. And we know that often legal problems are caused by intersecting social, health, financial circumstances. Equity, the system should be fair and accessible for all. Access shouldn't depend on your capacity to pay. Efficiency, the system should deliver outcomes in the most efficient way possible. And effectiveness, the system should work so as to deliver the best outcomes. But how do we fare when we examine the current system against these principles? On the equity front, not very well. When people who can't afford a private lawyer turn to legal assistance services for help, they find services either strictly limited in their eligibility or their scope. For example, to get a grant of legal aid, you basically have to have a poverty line income, have the right type of legal matter, either a criminal law matter where you're facing jail or a family law dispute only involving kids, not property, and also have low assets. Interestingly, analysis by the National CLC Women's Legal Service Network highlights a problem of equity even within this limited eligibility framework. The bulk of legal assistance spending nationally goes to legal aid commissions. The bulk of this funding in turn goes on grants of legal aid. But because of the heavy focus on legal aid for criminal matters and the fact that crime is mainly serious crimes mainly perpetrated by men, around the country around 60 to 70% of legal aid grants go to men. In other words, there's a systemic bias in the funding arrangement that denies women an equitable share of legal assistance funding. To some extent, CLC services alleviate this because only 7% of our work is crime. There's a bit of a myth out there that CLCs do a heap of crime, only do 7% across the board in Victoria. We focus on family law, family violence prevention and civil law. Around 60% of our clients are women. But CLC funding is around 1/7 of legal aid commission funding, so the overall bias remains, particularly when Indigenous legal service funding with its crime focus is taken into account. Of course, you can't ignore issues like High Court case called Dietrich, the Legal Aid Commission Act. I understand that courts can order legal aid to fund accused people in particular circumstances, but I think we need consideration and discussion of these issues around gender equity in legal assistance. In terms of Geographic equity and equitable safety net would seek to ensure that regions had similar access to services. Even looking at Victoria, we know this isn't the case. Peter's going to talk about his experiences in Bendigo and the Golden Valley, but sadly there's more examples of areas with little or no access to CLC services. Gippsland CLC has very poor funding relative to its huge service area, stretching from essentially Pakenham to Pakenham to Malakuta. I'll get my geography right. Yarra Ranges is only served by frequent outreach services, and areas affected by bushfires like Marysville and Mansfield further afield still have no local CLC services. Parts of Western Victoria around Horsham and Hamilton have little or no access to a CLC. And then Mildura stands out as the main region in Victoria, which, although it has access to a local CLC, has no access to a Victoria Legal Aid office. And I understand Victoria Legal Aid has done analysis which shows that where there isn't a local legal aid office, access to services is reduced. So you need a local legal aid office in addition to the local CLC. What's required in terms of funding to establish proper equity of access across the board is a challenging task. So we're not saying it's easy to work out how many people are missing out on legal help and how easy it is or what funding you require to provide legal help to all of those people. The Community Law Australia campaign is calling for a doubling of the national legal assistance spending by the federal government. We think this is achievable, particularly when you take into account that the government currently spends around twice as much on its own legal services than it does on legal services for Australians who can't afford a lawyer. Tomorrow, the National Legal Needs Survey is being released in Canberra, and the current review of the National Partnership Agreement by the Allen Consulting Group, together with that evidence-based analysis of legal needs, we've got a crucial opportunity to analyse the best available evidence and quantify what is required in terms of funding to meet that justice gap. In terms of efficiency and effectiveness, I think the NBA again has got it right, but its focus on early intervention and prevention. CLCs have got a strong track record of delivering these services. The National Association of Community Legal Centres this year commissioned an independent economic cost-benefit analysis. There we go, economic cost-benefit again. This economic cost-benefit analysis found an average ratio of 1 to 18 in CLC services. In other words, every government dollar of funding invested returns around 18 times the economic benefit, leaving aside the moral imperative of ensuring equitable access to justice. One of the interesting things to come from the analysis was that the time taken on particular legal services didn't necessarily return an equivalent economic benefit. Or put simply, a little information and advice can go a long way. So the current bias in government spending on courts and tribunals relative to legal assistance services needs to be considered. As Robert McClellan, former Attorney General, said, there's a mismatch in the justice system between supply and demand. The federal government can spend $1 million. What it gets in terms of return for that is 60 federal court cases, or 10,000 legal advice services, or 60,000 legal information services. And that's what Bob McClellan's talking about, it's a mismatch between supply and demand. So an efficient and effective legal safety net would have a strong focus on early intervention and prevention, ensuring the equivalent of services like the Fitzroy Law Handbook online, currently getting around 1 million visits a year. The successful New South Wales Law Access telephone service are available for free in every jurisdiction across Australia. Final word on early intervention and prevention. I think it's critical that we recognise that preventative legal work includes law reform work. As Michael Kirby said in the foreword to a recent CLC report, I learned 30 years ago that to provide effective laws and lawyering, it's necessary to go beyond solving immediate problems. Lurching from one problem to the next without examining the underlying causes of difficulty leads to a band-aid mentality. I'd encourage you to read the Chairperson's and Executive Officer report in our annual report, which talks about early intervention and some of the prevention projects that the Federation has been involved in over the past few years. I'm running out of time, but I wanted to end with two last comments. Firstly, on pro bono. There's a myth out there that pro bono is the answer to meeting a huge unmet demand for legal assistance. Together with a few people in the pro bono world, we've been crunching the numbers to show that pro bono cannot possibly meet the demand created by government underfunding of legal assistance services. The National Pro Bono Resource Centre large law firm survey results came out on Friday. It showed that pro bono by 36 of the nation's 51 largest firms, including all the major national firms, are equates to 191 lawyers working full-time for free each year. Impressive and rightly to be commended. Add to that the National Association of Community Legal Centres Volunteer Survey results, based on which we estimate that lawyers, not talking about law students, lawyers volunteering at CLCs add another 123 lawyers working full-time for free each year in this country. Again, a great contribution and rightly commended. Let's put those 300 or so plus extra lawyers in context. There's about 60,000 lawyers across Australia. That will cause a shock to some people. There are 2,000 lawyers working in CLC's legal aid and Indigenous legal services across Australia, some admittedly part-time. Legal aid work by private lawyers there equivalent to another 1,000 legal aid lawyers. So we've got about 3,000 lawyers working in the legal assistance sector relative to roughly 300 additional lawyers from pro bono and volunteering. So pro bono and volunteer contribution is significant, but it's only a fraction of that broader work. Further, more than half the pro bono work by large law firms is done for organisations, not for individuals. That's because it's a better fit for their expertise. So it's a big discount factor if we're talking about the access to justice gap for individuals about these 300 extra pro bono lawyers. I don't want to discount the importance of doing free legal work for non-profits. It helps non-profits like the Federation deliver services to individuals. It's absolutely critical, but it doesn't help to address that justice gap that is caused by government underfunding. Then there's the expertise gaps in pro bono around areas like family law, which from Pilch and National Pro Bono Resource Centre stats, it has the highest rejection rate of all areas of pro bono. So even if pro bono and volunteer contribution of lawyers doubled, it would still only fractionally increase the overall capacity of legal assistance services. It would of course be a welcome increase, but it wouldn't be the foundation on which you base a proper legal safety net in Australia. I wanted to end by talking about the complementarity, I don't know if that's a word, of the legal assistance sector, and it's an issue I've given a lot of thought to over the past few years. I'll end by saying that I think a proper legal safety net in Australia has the existing 4 pillars of legal assistance. That is legal aid commissions, community legal centres, Indigenous legal services, and the private profession doing legally aided funded work or pro bono. Yes, there's ongoing discussion about the relative share of funding and the need to improve integration, coordination and data collection. I think the current framework is a critical part of the proper legal safety net, with each arm playing a distinct but unique role, a distinct vital role. The CLC's that unique role relates to issues like our use of volunteers and pro bono, our focus on legal education and law reform, and our holistic service delivery, integrating legal services with non-legal services like health, housing and financial counselling. Of the 50 Victorian CLCs, around 20 are organisations that themselves deliver allied non-legal or paralegal services, and the vast majority of the remainder are either co-located with allied non-legal services or deliver outreach services in those locations. So we've got, for example, West Heidelberg located with Manual Community Health Centre, or North Melbourne CLC, a standalone CLC but delivering outreach services at the Royal Women's Hospital, Centre Against Sexual Assault House and Osmond Community Centre, delivering services to people getting drug and alcohol treatment. I just wanted to end by acknowledging the great work done by the staff of the Federation. So I'm very lucky to work with an extremely talented and motivated bunch of staff who share my passion for access to justice. On that note, I want to hand over to someone else who shares that passion. He's a thought leader within CLCs. He's played a leading role in setting up the Long Campaspe Community Legal Centre based in Bendigo, and now the Golden Valley Community Legal Centre set in Shepparton. So please welcome Peter Noble.